why the law really hasn't changed, the names have changed. The true owner trumps the legal owner. The problem is getting a judge to admit to that, because judges work in law, they work in legal, man's world, not truth. So, everybody got the basis of what's going on here. When you buy a home, by giving them your promissory note, you become the true owner. When they do all these fraudulent documents, they become the legal owner. Now, in law, they're not even supposed to be able to argue against you, but they do. The reason they're able to win these arguments is every state that I've dealt with, there's what's called a presumption of law. Does everybody understand what presumption means and how important it is in law? Okay. Most of you, based on your brainwashing, believe that there's something in the Constitution about two things: separation of church and state, and innocent until proven guilty. Neither one are in the Constitution. Separation of church and state came from a letter between a couple of the founding fathers, because in most of the colonies you had to belong to a religious sect to become a politician. Then the innocent until proven guilty came from a case that went to the Supreme Court a long time ago that is greatly altered. We're even changing the law, the case, what we all know as Miranda rights, which is Miranda v. Arizona, 1962. Or it might have been 66. Yeah. That case is getting overturned on a regular basis. In law, in the United States now, there's really no presumption of innocence anymore. You're no longer innocent until proven guilty. A lawyer that tells you that is either very mentally deranged, or he sold his soul twice, so he can't even do business well. So the way the law is now, you are guilty until proven rich. And you really have to understand that. That's a requirement in criminal law. If you don't understand that, you're going to have a problem if you get a criminal charge. So presumptions are very important, whether it be civil or criminal law. When the bank starts a non-judicial proceeding, or a judicial proceeding in some states, there is a law somewhere on the books in that state that says that the banks are presumed to be correct. Their documents are presumed to be valid. Basically, that means that you are presumed to be lying. Do you understand that? Do you understand how screwed you are when you first go to court? So a lot of what we do is about reversing that presumption before you go to court. Because if you go to court, all of those presumptions where the bank is correct and you're wrong are almost impossible to reverse in court. No matter what happens in court, if they're presumed to be telling the truth and you're presumed to be a liar, then everything you put in there is going to be presumed to be lying. Do you understand that? You must reverse that presumption. That's very difficult to do. That's why we do a lot of affidavits. I've been yelling and screaming, and I don't know if you've caught on, but I can be a real ass at times when I'm teaching. That's where my strong point is. So I screamed for a long time about getting a title abstract or somebody to check title. We weren't able to do it. So Cindy took it on, and she's a title abstractor now. The reason being, the way the law is affidavits are preeminent in law. Okay, cases can be won or lost strictly by affidavits. Evidence notwithstanding, and irrespective of facts. Cases can be won and lost off affidavits. In other words, if you have a title abstractor that says this chain of title is broken and may not even know where, say that I can see it up to here and it's over here, but I don't know how it got there. Once a chain is broken, it's broken. They can't really start it back up again. Title has to flow from one to another to another. Do we all understand that? Okay, so when somebody says it's broken right here, nobody can recapture title. You can't. You've got that in and of itself is a whole problem that takes years. So they can't foreclose without having title. Now, how do we establish that? Do you bitch and complain and whine like a little schoolgirl because you're not getting your way? Or do you have another party who is an expert sign an affidavit? Which would you guys choose? My suggestion too, I concur. So when somebody puts in an affidavit, now you get all these affidavit of facts, affidavit of truth, and that's fine. An affidavit is about facts and truth. It's like he's an evil attorney. It's a little bit redundant, just say he's an attorney. So, and if there's any attorneys in here, I apologize. I will beat on attorneys and most of my friends are attorneys, and that's just a scary friggin' thought. So, and I beat on them, and then again, I have cop friends too, and that's really bizarre for me. So, when you look at an affidavit in a court case, the attorneys will complain. They will bitch about that affidavit. They will say, blah, 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 this doesn't matter, this doesn't matter. Do you understand that that doesn't count? The only way that you can rebut an affidavit in law is with another affidavit. Here's where we got them. We get them every time. We kick their butts on this. Now, let me step back for a second. It doesn't always have to be necessarily a written affidavit, and I shouldn't say affidavit. I should say under penalty of perjury, okay? Because you can rebut an affidavit in open court if you're willing to affirm or give an oath and take the stand and go under penalty of perjury. You can rebut an affidavit. Hasn't happened in one of our cases yet. You do some kind of affidavit in the court, and the attorneys are not going to go under penalty of perjury to argue against your affidavit. So far, the first time I tried this was, with a girl that had several homes, and she was just getting her butt kicked. She came from one of the Patriot groups, and had lost some of her homes, and she heard about us, and it's like, I got to keep at least one home. And so she was willing to fight real hard. We do a mock court on every Sunday, and she practiced and everything. And she was getting, when she went into court, she was getting her butt kicked. And you got to understand, this means a lot to me. I mean, to the point where I don't make any money at it, and this is my whole life. I literally live like a dog. And so I'm upset, and I'm back in that gallery, and I'm about ready to jump over that bench, and my head right on the bar. And I mean, it was loud, the hollow sound. It rang through the court. So she's like, and she just caught on fire. And she's like, well, Your Honor, we can resolve this really quickly by just having the attorney admit on and for the record whether his clients are the creditor and the holder in due course. And the judge is like, oh, shit. I mean, he just kind of looked around the room. It's like, he kind of moved back a little and goes, and then he started talking to the attorney, acting like he did not hear this. It took her 5 times to say that. He tried to ignore her 5 times with a gallery full of witnesses because he knew that was it. Finally, he had to look, because she literally is like, no, you will get this attorney to stipulate and admit on him for the record. Finally, the judge says, okay, you've said it enough, which tells me a lot. You've said it enough. Okay, the first time they miss it, that can be like he didn't hear you. The second time, maybe he didn't understand you. The third time can be a mistake. The fourth time's criminal. It's flat out criminal. He's just proved his bias. He's toast. So the attorney gets up and he's like, well, I can't do that. And he is walking. He's literally walking. The clerk's over there. Cheryl's desk is there. His is here. were obviously behind her. There's two sides of a courtroom, plaintiff and defendant. Do not sit on the wrong side. You can go to jail for that. So he gets up, and he's walking behind her, and I'm like right here because he is on fire. He is lit up. First time in my life I was ever glad there was metal detectors in there, because I guarantee you if he had a gun, he would have killed everybody in that courtroom. He is lit up. He's, the guy's an ass too. And he's older, and he was this shy of a heart attack, and I would have faked CPR. So, but he goes over to the clerk, and I mean, he makes 5 trips back and forth. This guy is lit up. He cannot do this. He's toast. We just wiped him out. That's it. Because he can't do it. So he asked for an extension. She got another 30 days, blah, blah, blah. The reason being, if an attorney was to say it in open court, she could force the issue under penalty of perjury. Is he lying to the court? Attorney's not allowed to lie to the court. Attorneys aren't allowed to lie. Politicians can't take bribes. Yeah. You know, some rules just crack me up. Isn't it funny how it always appears that the ones that swear an oath to protect the Constitution are always the first ones to violate it and always appear to hate it the most? Most people, most Americans, if they read it, I got to be careful with that because most Americans don't read the Constitution. I hear people quote the Constitution. I had a judge, when Cindy was giving the intro, talked about my little bitch slap session on a judge a couple of months ago, and this poor lady tried to quote the Constitution to me. Don't do it. I don't care if you're a judge, but you sure as hell don't want to quote the Constitution to me and be wrong. She's like, I read the Constitution all the time. And I'm like, then why don't you know what it says? So when you start dealing in that aspect of law and you start going through all of the concepts that direct you in law, you need to know where you're going. When you start talking about an affidavit, you need to understand that aspect is written. This is ridiculous. An affidavit is written, but it's the same as, okay, hold on, please. Marty, anybody with the microphone, when you see a hand go up, let's just do this thing because we're going to run out of time. Being under oath is basically the same thing. So they're pretty much interchangeable. I will mistakenly say affidavit when I mean somebody's under oath, or they said this under oath when they really did it in an affidavit. It's fundamentally the same thing. If they're going to attempt to rebut what you do under oath or in an affidavit, you got to go all the way back through law, and you'll find out that the only way they can do that is to be under oath or in an affidavit. So if you do an affidavit like Cindy's or Bill's or one of these that says there's a broken chain of title and shows where it is, they're going to try and rebut it in their pleadings. They can't. You can demand that they do it under oath. Yeah.
Hello? Yeah. About the story of the attorney and the court case, just make sure that I captured it clear. The issue was there that the lady was asking the attorney